thanks so much for joining me this morning. My name's Andrea Collins. I am MD of the Export Department, and I'm delighted to be able to deliver today's webinar all around service companies adjusting to the new way of trading with the EU on behalf of the Southwest Growth Hub Cluster. So before I say any more, I'd like to ask Richard Morgan from the Growth Hub just to unmute himself and do a little bit of blurb about the Growth Hub, Richard, if that's okay, before I start. Are you there, Richard? Richard, are you there? Oh, Richard, do you need to unmute yourself? I can't hear you. I don't know whether anybody else can. No, we can't hear you. Oh, we love all of this technology. Shall I crack on and give you a minute or two to see what's going on at your side, if that's okay? Perfect. All right then, just make sure that we've got everybody coming in. So again, yes, this morning we're going to be talking all about services. So bear with me just 2 seconds. I'll just adjust a couple of things on my side. So by means of an agenda, we're going to be talking about where we are now. So, you know, the landscape post EU transition, talking a little bit about our service exports historically, because we operate a surplus in terms of our export of services and a deficit in terms of goods. We're going to be talking a little bit about the different modes of service provision. So I'll show you kind of like the quadrant all around cross-border sales and in-company presence and so on. We'll talk about cross-border trade post-transition. We'll talk about the movement of people. We'll talk about how we now need to negotiate individual member states jurisdictions around the movement of what we call natural persons. We'll talk about where we're at with regard to mutual recognition of qualifications. And then I just want to draw your attention to a couple of directives that we're no longer part of and the implications that they have on various sectors. The EU VAT directive being a big one, not just on services companies, but also on the movement of goods as well. The loss of the EU VAT directive is causing some pain. We'll talk a bit about GDPR and the advancements there in terms of negotiations, where we're at, because that actually wasn't resolved when the Trade and Cooperation Agreement was announced on the 24th of December. We'll talk about intellectual property, specific provisions around technology and innovation, legal services, financial services, where we're at in terms of the negotiation around financial services. Just letting some more people in. And we'll talk a bit about commercial agreements, what needs to happen with those, and then we'll go through a checklist finally, things that you need to be thinking about going away from today. If you haven't already started to address those points, then what you need to be thinking about. Okay, so in terms of where we're at, so there's no longer any single market. So effectively, GATS replaces the single market, and you know that access to the single market has allowed a level of freedom to us as service providers that cannot be replicated in any free trade agreement. It isn't replicated in any free trade agreement with the EU, because typically in terms of delivery of services into those third countries, there are typically greater restrictions on market access for third countries and selling services into the EU. So within the single market, we've been treated as local businesses. We haven't had to navigate individual countries' administrative processes and rules, but now, as I say, we're going to have to start consulting the jurisdiction of the market where we're going to sell that service into, and it'll depend very much on its WTO provisions for trade and services as to how easy it is to trade within that market. So, you know, lots of things to consider there, whether you need an authorization or a license to provide your service, whether your professional qualifications in the UK will be recognized in that member state, whether you need to comply with any specific local business regulations, lots of things really to consider now. Obviously, we've got this touches on goods more than services, but you know, some of you may be selling services and goods, to be honest. Just let somebody else in. So, you know, where we're at the minute is obviously we've got no access to those EU free trade agreements, those 70 plus free trade agreements that have been negotiated on our behalf globally. We're out of the EU VAT scheme, which is causing pain more for the supply of goods, to be honest, than the supply of services. We've now got the UK customs territory, which replaces our membership of the EU customs territory. So in the case of, you know, importing goods, for example, goods that have been cleared for import into the UK are only free to circulate within the UK customs territory. If they're subsequently exported to the EU, then perhaps they face a tariff on that export. So that free circulation of goods has gone. We've now got third country rules which apply to our provision of services and goods. We've got, in terms of the supply of goods, we've got customs formalities and border controls to navigate, which, you know, it's as the final bullet point there says, it's been a bumpy start on both sides of the channel so far in terms of navigating those formalities and border controls. The UK courts replace the European Court of Justice. I've got an asterisk there because there is one or two circumstances where the ECJ is still involved. And obviously we've now got this EU-UK Trade and Cooperation Agreement in force, which is, as you would expect, quite detailed in terms of the supply of goods, but quite light in terms of the supply of services. And now we've got the UK government playing catch up to negotiate free trade agreements globally that can replicate what we had in our preferential trading scheme as part of the EU. So, you know, making good headway in many respects. They're a bit on the back foot because they couldn't actually negotiate anything until the transition period started. So they've only really had just over a year at this. I suppose major wins have been obviously the free trade agreement with Japan, which is a major coup because it's a direct replica of the EU Japan agreement. Singapore, obviously we've got a decision in principle from Canada and so on, but it's going to take some time to replicate what we had as part of the EU. And as I say, it's been a bumpy start on both sides of the channel so far. But we'll find our rhythm, we'll find our feet. I just wanted to give some kind of context to the supply of service so far. So I think for me, a major source of frustration throughout the Brexit negotiations, I shouldn't say Brexit actually, EU exit negotiations, was that much of the negotiation preparation and press coverage concern trade in goods, and yet if you think about it, we're really a services-based economy. So it's 80% of our economy is services-based. So this first slide shows just how reliant the UK is on service exports. If you compare our figures to those of the US and France and Germany and the EU as a whole, we actually, as I said earlier, operate a trade surplus in services compared to our trade deficit in goods. And I thought it might also be quite interesting to take a look at services, service exports by region as well. So not surprisingly, we see that London and the South East contribute some 58% of overall service exports between them. But you can see we've got the Southwest in there contributing 13 billion per annum. So very much dependent on those services exports, just letting more people in. Also, just some more statistics. So in the graph on the right, I've provided a breakdown of services exports by type, and it becomes clear why much of the negotiation challenges surrounded financial services. And actually, indeed, while there's still no clear agreement there, the financial services sector is obviously of great importance to the UK economy, and we have a particularly strong position and brand equity within EU member states. and that's contributed to really our export services success, if you like. So the City of London has become a leading financial sector within the EU. In the first graph, you can see how our service exports have been so reliant on free access to our closest neighbours. So you can see that failure to replicate that in the UK-EU free trade agreement means that we'll undoubtedly see some contraction in the sector, at least in the immediate to medium term. And really the dominance of EU market for UK services export doesn't really come as a surprise, because when we look at research around trade and services, those trade flows in services are typically greater between neighbouring countries, but it's actually the degree of market access that's been allowed by the single market that's really driven this trend, and why we supply so many services into the EU. Because the single market, as I said, allows far more access than any FTA will facilitate. And as I said earlier, there's no FTA that can replicate the freedoms and protections afforded by the single market. So just really giving you some background as to where we're at really in terms of our services exports. I wanted to talk about the different modes of service provision, because depending on the type of business that you're in, or where you're at in your growth model or maturity perhaps, will dictate which part of the quadrant you sit in. But policies, global policies that facilitate or impede services trade come in many shapes or forms, and partly because individual service sectors are very different. So legal services is very different to healthcare, for example, and also partly because services can be exchanged in many different ways, and some of those exchanges or transactions mean different permits or licenses, or can be subject to different domestic regulations. So here I've provided what we call a modes of service delivery matrix, quadrant, whatever you like. The first one being cross-border service. So that's where the service itself crosses the border from one country to another without the movement of persons. So, via electronic means or bioinfrastructure or telecommunications. So we see this a lot in management consulting, information and communication, marketing, consulting, health, and so on. Then we've got consumption abroad, and this is where the consumer crosses the border to another country to actually use the service. So the supplier of the service who's being paid by a non-resident customer is technically exporting a service even without leaving the country. So we see that with tourism, education, legal, health. And then we've got commercial presence. So that's where a company from one country sets up subsidiaries or a branch, for example, to provide services in that other country. So we see that a lot in financial services, construction, IT, distribution. And then we've got movement of natural persons, which I'm going to focus on throughout today, because there are some significant changes to our permission to enter or work in EU member states now. So the movement of natural persons refers to individuals that travel from their own country to supply services in that other country. So we see that with arts, construction, education, recreation and sporting, for example. Now the single market had facilitated the true integration of EU services markets by what we call the country of origin principle. That meant that when a service was supplied cross-border into another member state, the law and rules in the originating country were what governed that transaction. So UK companies were governed by UK laws and rules when supplying services into the EU. And this kind of regulatory approach in the single market is seen in broadcasting, and it's seen in financial services, and where we call it passporting and financial services. And then obviously another significant part of the single market is the mutual recognition of qualifications for a range of professions, and we'll touch on that in a bit. So the UK's departure from the single market has removed these easements, if you like, and these facilitations. So in many cases, instead of complying with the country of origin principle, like laws pertaining to the UK companies are now going to have to navigate regulation at the individual member state level. which obviously can be quite burdensome when you're supplying into multiple member states. So in terms of cross-border trade, so the UK-EU Trade and Cooperation Agreement, that fantastic 12,000 plus page document, great bedtime reading, sets out conditions under which, let somebody else in, under which UK businesses can supply services according to the rules within that host country. And obviously this constitutes a huge change from the economic freedoms, cross-border trade and establishment in the UK single market that we had before. But, you know, this is where we're at. We have to be quite pragmatic about this. The TCA does appear to be quite ambitious in a few sectors. So telecommunications in particular, international maritime transport and digital trade, where strong disciplines are kind of uncontroversial. But important exclusions from the scope of the agreement are audiovisual services and financial services. The exclusion of audiovisual services doesn't come as a huge surprise, to be honest. It was a real sticking point in the negotiations, and it's a standard approach by the EU in all FTAs not to include that sector. But it's a real blow for the UK because we have such a strong position in areas such as broadcasting, media and some creative industries. So decisions on the future governance of financial services, which is another one that's been excluded, are still up in the air at the moment. So we didn't reach resolution or conclusion before the TCA was announced in December, but both sides have committed to reaching a memorandum of understanding regarding regulatory cooperation by the end of this month, which is a bit tight. There's no white smoke to date, so we await to hear on that. There's no doubt that those regulations perceived as those sectors, where they're perceived to be regulation intensive, like aviation, road haulage, the financial sector, and some businesses that make up part of the professional and business services sector are going to face quite substantial new barriers to exporting their services to the EU. And as we saw on the earlier slide, those sectors constitute quite a substantial share of UK services trade. Obviously, as I mentioned earlier, that country of origin principle no longer applies to UK service providers, so we have to carefully check EU commitments at the member state level to determine the conditions that apply to the provision of the service in that market. Just a quick note on commercial presence. So that's mode 3 on the service provision quadrant. Within the TCA, the EU has agreed that neither party can require the other to establish a presence in that market for the purpose of cross-border service. And that's actually the only time that the second time that the EU has agreed a separate obligation on local presence, if you like. But that withdrawal from the single market is definitely going to make it more difficult for businesses to establish a local presence. So they might face restrictions on owning, managing or directing a company registered in the EU. There may be additional requirements on the nationality or residency of senior managers or directors, and there might be limits on the amount of equity that can be held by non-nationals. So very different landscape in terms of that local presence as well. In terms of the movement of people, so the TCA brings the freedom of movement of citizens between the EU and the UK to an end. So, you know, we had free movement of labour and people. That's come to an end. So the current provisions within the TCA appear to favour the exchange of what we'd call high-skilled professionals. Now, this might make it hard to realise gains from trade with partner economies wanting to send lower-skilled labour to the UK, but the TCA definitely favours that inflow of high-skilled professionals. In terms of EU nationals in the UK, so obviously the rights have changed. Citizens and their family members who've been living in the UK before the 1st of January now need to apply to the EU settlement scheme, and that needs to be done before the 30th of June, regardless of how long they've been resident in the UK. Settlement is not granted automatically, so they have to apply. The government obviously has created this toolkit that some some employers are using to publicise the scheme. There's no obligation on employers to publicise the scheme, actually. It's 100% the obligation of the employee to make an application to the EU settlement scheme. UK nationals in the EU, quite similar. So, you know, if they're legally resident in an EU country before the 1st of January, have their rights, they have their rights protected by the withdrawal agreement. So broadly the same rights of work, study and access to public services and benefits as before. But resident documents and status, they may need to apply for a new resident status to secure rights under the withdrawal agreement. So each member state operates a slightly different scheme. Their access to healthcare, education and so on in the UK is unaffected, it's unchanged. In terms of hiring EU nationals in the UK, obviously we've now got the new points-based immigration system. So it's aimed at ensuring that employers are treating EU and non-EU nationals in the same way. So the system basically says that UK business owners now need to be a licensed sponsor to hire eligible workers from outside of the UK. Estimated to take about 8 weeks, and there's a cost associated with it. Obviously, this system doesn't apply to hiring Irish citizens or EU citizens already living and working in the UK who are eligible under the EU settlement scheme. Business travellers to the EU. So the EU is allowing UK business travellers to spend 90 days in any 180-day period without getting a visa or a work permit. There are certain circumstances with Bulgaria, Croatia, Cyprus and Romania that form a separate block where they permit an additional 90 days. So technically could have, what's that, 180 days period in there. If travel is estimated to be for longer, or the certain conditions apply, so if you're transferring from a UK branch of a company to a branch in a different company, so that intra-corporate transfer, even for a short period of time, you might need a visa or a work permit. If you're carrying out contracts to provide a service to a client in another country where the employer has no premises, that might require a visa or a permit. And if you're providing services in another country as a self-employed person, you may require a visa or a permit. But we're going to touch on some of that in a little bit. In terms of EU travel, so there's tons of information on the government website about that. We're back to third country rules, so you know, the same things that we require of people coming into the UK from a third country. They have to have a certain amount of time left on their passport. We may ask them to show an onward ticket or show that they've got sufficient money for their stay. You know, we might route them through different lines now and so on at the border controls. So all of this applies. I suppose another thing to mention is, and again, there's more information on the government website, ATA carnets are something that a lot of clients are just getting their heads around now. So that relates to temporary exports. So they may be required for the movement of specific goods into the EU on a temporary basis. So if you're taking samples to a trade show or exhibition equipment, for example, cameras or sound equipment, then you may need an ATA carnet for that temporary export to make sure that you don't pay duty and VAT when those goods are brought back into the UK. The rule of thumb, depending on the type, the frequency and the length of stay, consult country destination guides just to be absolutely sure that you're compliant. With EU business travellers to the UK, so it's reciprocated access as per the TCA. Not much to say on that one, really. Short-term business travellers, we'll come on to it a little bit more in a second, but the TCA lays out definitions of short-term business visitors and how both sides will permit entry. So, you know, things like market research, after sales, service and so on. Contractual service suppliers and independent professionals, so mode 4 of the service supply, you know, presence of persons, they might be subjected to economic needs tests or labour market tests. So their kind of pre-employment conditions, residency and training requirements. We'll cover off some of that in a second. And the important thing to mention here is that those conditions will vary per member state, and I've got some examples for you in a second. In terms of forgotten industries, there's no visa-free travel for sports professionals, artists and musicians. Those temporary passports for goods, so the carnets that I just referred to before, are going to have to be used by the likes of musicians and sports people moving their gear. They're going to be costly, and they're going to demand, you know, extensive paperwork, or certainly more paperwork than we've been used to. We've obviously withdrawn from the Erasmus scheme, and that's been replaced by the Turing scheme, I can't talk today, which is funding for placements and exchanges starting September 2021, so support students to study and work abroad. And then we've got participation in certain EU programmes. So we've got continued participation in those flagship EU programmes for taking us through from this year through to 2027. Obviously, we're making a substantial contribution financially to the EU budget for this, but we've got continued access to Horizon Europe, Euratom, Interreg, Copernicus, and EU space surveillance, and the Peace Plus programme. So that has been negotiated separately, and that's you know, seen to be a coup for the sectors that are involved in those EU programmes. In terms of temporary stay, so this is kind of like the movement of those natural persons that were referred to earlier. So both the UK and the EU are WTO members, okay, so we both abide by most favoured nation principles and other fair trading or fair playing field regulations. And the WTO sets out guidelines around the movement of natural persons in its GATS framework, so the General Agreement on Trade and Services. Most WTO members will have committed to unbound conditions. That means, you know, they won't bind access to their country, but then they'll qualify that by granting admission to selected categories of people, often with a marked bias towards people linked to perhaps a commercial presence, so intra-corporate transferees, or highly skilled people, so managers, executives, and specialists. And then in addition to limiting access to certain types of people, it's not uncommon to see members, WTO members, then add other restrictions like defining the duration of stay, quotas perhaps, so including the number of proportion of foreigners employed. They may impose economic needs tests like I mentioned before, and also other conditions may actually apply. In the TCA, these WTO terms are effectively what replaced the free movement of people. So we had that as part of the single market. We don't have it anymore, and so the TCA refers very much to these different conditions. So the agreement categorises 5 different types of individuals permitted to stay in the EU temporarily for business purposes. So it refers to business visitors for establishment purposes, and that's really natural persons who enter that market for the purpose of setting up an enterprise in that EU member state. They refer also to intra-corporate transferees, so those natural persons employed not less than 1 year and not less than 6 months in the case of a trainee employee. They refer to short-term business visitors, so again, natural persons permitted to carry out certain activities listed in the TCA, so you'll see things like after-sales care, installation, and so on. And then they refer to contractual service suppliers, so natural persons employed not by an agency, very firm that it excludes employees contracted through an agency, that are employed by a company that's not established in the territory for no more than 12 months. And then they refer to independent professionals, and that's those natural persons who are self-employed in the territory for the purpose of you know, supplying their services, and again can't exceed 12 months. And this is really where they put a lot of further restrictions or conditions on these individuals. So, you know, they'll stipulate that they must have 6 years professional experience in the relevant activity. They may stipulate that there's a university degree or a qualification that demonstrates the level of knowledge and specialism that they have. And again, you know, that duration of stay is limited to 90 days in any 6-month period. So each member state is permitted, as I said before, to demand a certain criteria be met before market access is granted. And we've got some situations where the TCA is really very, very detailed on this, and you can go in and understand, you know, the category of person, the market that you're looking to penetrate, and what the entry requirements are. But we've got a situation whereby in, say, Austria and the Czech Republic, a business visitor for establishment purposes needs to work for an enterprise other than a non-profit organisation. But in Slovakia, all of that applies, but the individual also has to have a work permit, and access will be subject to an economics needs test. So you're getting that kind of variation between member states. In Austria, Czech Republic and Slovakia, an intra-corporate transferee needs to be employed by an enterprise other than a non-profit organisation, which we see a lot, to be fair. But in Hungary, natural persons who have been a partner in an enterprise do not qualify to be transferred as intra-corporate transferees. So that's an additional condition. In the case of short-term business visitors, individuals involved in, that after sales or after lease service that I referred to, they're going to require a work permit and economics needs test in Austria, but that economics needs test is waived if that natural person's training workers to supply services and processes specialised and possesses that kind of specialised knowledge. So it's really important that you understand the category of employee that is looking to access that member state, what services they're looking to deliver, and clearly understand the kind of conditions that that member state is placing on the right to work there. Lots of other examples I could give you, but it would just take too long. In terms of mutual recognition of professionals, so there's no automatic mutual recognition of professionals or professional qualifications in the TCA, but there is reference to a framework allowing professional bodies to move in this direction in the future. So there's some special protection for lawyers advising on UK or public international law, which we'll touch on in a bit when we talk about legal services. The UK really wanted mutual recognition of professional qualifications to be managed at the EU level. And I remember talking about this last year, but the EU was adamant that it wanted it to be up to local jurisdiction. So the TCA effectively allows for that bilateral recognition between regulators and authorised bodies between the UK and each individual member state. So we could see a kind of patchwork picture emerging in the future where some countries' qualifications are going to be recognised cross-border, and they're going to make it easier to supply those services than in other member states. The UK was definitely pushing for more ambitious mutual recognition provisions, and obviously a lot of us in the service sector were hoping that they'd be successful in that as well, but the EU just wouldn't concede. So if you think about how it compares to other free trade agreements, it's broadly in line with other FTAs. So it's got no more in there than the EU-Canada agreement. I have to say what doesn't bode particularly well is that there's been no real movement in terms of mutual recognition within the EU-Canada agreement. But like I say, there is this kind of process where regulators and industry bodies can work with each other to establish those mutual recognition of professional qualifications in the future. So both sides, so an EU member state and the UK, can go to the EU Partnership Council and ask for profession-specific arrangements. But it's going to, excuse me, it's going to really depend largely on the member states, industry bodies, and additional constraints on labour mobility as to how successful we are in this area. So think about it, architects are less protectionist than other industries, for instance, whereas accountancy or something like that could be more challenging. So what can you do in terms of the actions you can take? Well, I suppose firstly ensure that any employees currently providing cross-border services within regulated professions register to protect their rights under the withdrawal agreement, and in some circumstances, they may be grandfathered. Monitor the requirements in each member state where you provide your services to. Register with those regulated bodies so you can be kept up to date with changes, and ensure you take the appropriate steps before providing that cross-border services, which might obviously include registering with dual professional bodies, changing residence, or even requalifying in some circumstances. I just want to touch on a couple of things that we have been removed, so and the impact that they have on certain sectors. So the e-commerce directive no longer applies to the UK. So the EU Commerce Directive allowed EEA or EU online service providers to operate in any EU country, again, just abiding by those country of origin principles. But that framework no longer applies to the UK because we've left the EU, and so therefore we've left the EU. The EU commerce side, the e-commerce directive no longer applies. So that affects services that are normally, within the scope of payment, including indirect payments such as advertising revenue, electronic means at the individual request for a recipient of the service. So this obviously covers the vast majority of online service providers, so online retailers, video sharing sites, search tools, social media platforms, and so on. So the directive refers to the place of establishment. And that essentially refers to the fixed establishment where a business conducts its economic activity for an indefinite period of time. So companies now really need to familiarise themselves with the local jurisdiction of each member state, because we're outside of the EU. So those rules are referred to as the directive's coordinated field, and it lays out requirements in respect of online information, online advertising, online shopping, online contracting, and so on. So effectively, it's negotiating those individual member state jurisdictions. What the directive includes and doesn't include is also important to refer to. So really, it's a case of where you're impacted by the withdrawal of the EU Commerce Directive, or the e-commerce directive, sorry, just consult. The government website has a lot of information there in terms of what you need to do, but we are back to, having lost that country of origin principle, we are back to having to navigate local jurisdiction, if you like. The Audiovisual Media Services Directive, again, it works like the e-commerce directive, so the country of origin principle applies. Obviously, it no longer applies to services under UK jurisdiction that are broadcast into the EU. There is what we call the European Convention on Transfrontier Television, so the ECTT framework applies. So there's some 20 EU countries that have signed up, and in signing up, they're basically saying that they allow freedom of reception to services under UK jurisdiction. Effectively, what this all results in is where companies have a service that's available in the EU, they might now need two different types of licenses. So an Ofcom license for services receivable in the UK and in other ECTT countries would be permitted in those ECTT countries, but licenses covering services received in EU countries that haven't signed up to the ECTT, there'll be a different type of license for that. So really, companies need to refer to regulators in relevant member states to see if their license is valid. Ofcom licenses should be valid, but it could depend on national law. The ECTT doesn't provide for freedom of reception for video on demand services, so companies need to comply with the Audiovisual Media Services Directive rules, which are now, obviously, for the case of UK companies, they're determined locally by each member state. So there's a lot of things to think about if you're in this particular sector, because, like I say, we no longer have access to the same freedoms that we did have. The EU VAT directive, we have withdrawn from the EU VAT directive, so that's causing significant pain, certainly on the shipment of goods. But EU VAT rules no longer apply in Great Britain. So with goods, with the import of goods, for example, or the export of goods, then that consumption tax becomes an import tax, if you like. We've lost that triangulation that we enjoyed in terms of the shipment of goods for VAT purposes. In terms of the place of supply, VAT hasn't really changed. So in B2B transactions, VAT is where the customer resides. So the customer will account for it using the reverse charge. And there's no more completion of the EC sales list, if you like. For B2C transactions, they're subject to VAT. So it's where the customer, whether the supplier resides, probably, except in the case of digital services, and there's a couple of other exceptions there. We now we're now in the realms when we're shipping goods in particular, that obviously there are impacts on cash flow due to the imposition of VAT. So VAT becomes that import tax. So it's the time at which that VAT becomes payable that is problematic. And perhaps in certain circumstances, our shipments will be subject to duty as well. So there are various different deferment mechanisms that importers can use, from duty deferment accounts that they can apply for to postpone VAT accounting, which is something that's just been allowed from the 1st of January this year, and a number of companies are taking the HMRC up on that. Where it is where you're shipping goods outside of the UK, then you need to zero rate those goods for the purposes of VAT. You need to maintain that proof of export to show that the goods physically left the UK within 90 days of the declaration being processed. Otherwise, you become liable for the VAT. Some companies are looking to safeguard the customer experience when they're exporting to the EU, and are trying to deliver duty paid, as we call DDP, which sees them take accountability for the import declaration in the EU and cover any duties and VAT that's due. That, in order for them to reclaim that VAT, they're going to need a local VAT registration, and some 19 out of the 27 member states are insisting that UK companies registering for VAT in their member state have fiscal representation, which obviously implies another cost as well. The UK MOS system, which was the system to report and account for EU VAT on B2C digital services to EU consumers, no longer applies. So UK suppliers now have to switch from the UK VAT MOS system to a non-union scheme in an EU member state. So they have to choose an EU member state to register for non-union MOS to continue selling their digital services to consumers. As I said before, digital services are one of those exceptions to the B2C supply of services for VAT. We've lost EU distance selling rules for B2C sales of goods between the EU and the UK, which ties into what I was saying about DDP before, which is causing pain. The other thing I'd mention is all VAT refund claims, so where EU VAT is incurred on goods and services, now need to be made using the 13th VAT directive process. So UK businesses might be required to provide a certificate of trading or certificate of status in order to get a refund. So the process of reclaiming VAT that has been incurred on goods and services in the EU has changed, so you need to familiarise yourself with those changes. GDPR, I could summarise this very, very nicely by saying that the EU, thankfully, recently published its draft data adequacy decision, which effectively recognises the UK's data protection standards and sets out that the UK standards are adequate, which is such a relief. Though we were preparing a lot of companies for the end of the transition period, talking about contract clauses, safeguarding that transfer of data. The transfer of data from the UK to the EU was never in question, because the UK government hasn't questioned the EU data adequacy standards. It was for EEA data coming back the other way, so that personal data coming from the EU into the UK. But like I say, it wasn't finalised before they announced the Trade and Cooperation Agreement, but it was worked on subsequently, and we have got that draft data adequacy decision. The challenge now is getting that technical approval process done and dusted before that bridging mechanism expires on the 30th of June. So in the Trade and Cooperation Agreement, there's this bridging mechanism that said that UK companies could continue receiving EU personal data up until the end of April, and that could be extended up until the end of June. So really the challenge is the EU getting this whole technical approval process done before that bridging mechanism expires, because there's no actual provision for that mechanism to be extended within the TCA. Intellectual property, I'll just run through this very, very briefly because I'm conscious of time. So the UK has obtained the ability to set its own permanent regime for exhaustion of rights. So they'll be going to consultation on that early this year. That exhaustion of rights basically means that IP rights cannot be used to stop the further distribution or resale of those goods. With regard to trademarks, both parties have committed to retaining certain minimum standards. on trademarks, to be honest, all of which are already enshrined in EU and UK law, such as the type of signs that can constitute trademark and the grounds for revocation and so on. EU domains have to be transferred to an EU body or an EU entity pretty quickly before they're permanently suspended from the 1st of July. So that's something that you should be looking at if you've got a .eu domain. Designs, the TCA, has provisions on designs that are minimal, to be honest, and largely reflect the trade-related aspects of intellectual property rights, or the TRIPS agreement. So both parties have committed to having a system for the protection of independently created designs that are new or original. So protection being 25 years for registered designs and at least 3 years for unregistered designs. There's no agreement reached on the protection and enforcement of geographical indications. So they're those signs used on products that has specific geographical origin and possess qualities or reputation that are due to that origin. So the UK actually has its own system now. So the UK will continue to manage those GIs, if you like, for the EU and Northern Ireland, but the UK manages its own GI system now. The provisions for copyright are a relative restatement of the international copyright treaties with a few adjustments for the current state of EU law. Very little change in practice as a result of the TCA, but it does give some clear indications on what policy initiatives the UK might want to explore, because the government has highlighted copyright as an area that it may want to see future possible divergence. Just very, very conscious of time here, so rushing through. In terms of technology and innovation, so there's no mutual recognition on certified products. So the UK CA mark for electronics, machinery and consumer goods comes into force on the 1st of January. The C, and then, depending on where those products are being placed, there will be different marks that have to be used. So Northern Ireland will still carry the CE mark, and the UK CA mark is just for the GB marketplace. That whole Northern Ireland protocol has thrown a bit of a spanner in the works. We've got Northern Ireland suspended in this kind of hybrid model somewhere between the UK and the EU. So it's in the UK customs territory, but it's closely regulatory aligned to the EU and aligned in terms of VAT as well. Obviously, GDPR and data adequacy. So GDPR is now being incorporated into domestic law, so contracts should refer to UK GDPR, and that adequacy decision has been given but needs to be ratified. Digital trade, the EU had been really reluctant to incorporate digital trade in the TCA, so the inclusion of an entire chapter dedicated to digital trade was a real departure and quite a win for the UK in terms of those negotiations. So in relation to software and services, both sides of it have agreed to not impose customs duties or tariffs on electric transmissions such as software that are provided in its territory. They have adopted a really broad definition of computer-related services. They don't require businesses to obtain any prior authorization for any services purely because they're provided by electronic means. In relation to data localization, both parties have agreed not to require that the use of computing facilities or processing of data takes place in its territory. They've agreed not to make data transfers contingent on the use of computing facilities in its territory, and not to prohibit the storage or processing of data in the other party's territory. So all of this is fantastic and a departure from you know, how the EU would typically negotiate this side of things. Telecoms and mobile roaming, so a really open approach to telecoms market. So both the UK and the EU will allow providers to have access to and use each other's telecoms networks, not having to wait for prior authorization before they begin to deliver services. So it's a really high level of access that goes beyond what's traditionally included in free trade agreements. Cybersecurity, so the TCA has created a framework, if you like, for cooperation in the field of cybersecurity, as well as in the UK's participation in the activities of expert bodies such as the European Union Agency for Cybersecurity and so on. Providing services, so as we say, the UK-EU TCA provides coverage for services roughly equivalent to other EU free trade agreements, such as the EU-Canada and EU-Japan agreements. In the main, service suppliers will not require a visa for short-term trips or face limitations such as economic needs tests, but where those trips are, longer than a certain period of time, they may well have. And the actual TCA services chapter has a huge number of exemptions, that apply to local EU member states. Moving swiftly on. So within the single market, legal professionals had extensive access to EU legal markets, and they were able to establish under home title in any member state and offer advice in home or host law, including EU law. So they were also able to provide temporary cross-border legal services, but without the need to register with the host bar. They could gain the title of lawyer in another member state, either by 3 years practice of that state local law or by sitting a few examination papers without ever having to establish in that member state. Outside of the single market, the TCA actually has several positive aspects for the sector, certainly better than what would have been available under GATS. So GATS would have provided a much more limited scope for legal services. So the TCA covers obviously those several categories of personnel under movement of natural persons that aren't included in GATS. So there's independent professionals, short-term business visitors, and graduate trainees. The sector also has an entirely dedicated section in the TCA. UK lawyers are in principle allowed to supply legal services in EU member states using their home title in relation to home jurisdiction law and public international law. And although going back to kind of like, the WTO fair trading and so on, although each EU member state can set registration requirements in their territory, those registration requirements can't be less favourable than those that apply to lawyers from other third countries, and they can't amount to any requirement to requalify in order to be admitted to the legal profession within that territory. So that's a real cue as well. And then finally, financial services. So as I said earlier, not covered comprehensively in the TCA at all. There's really little by means of agreement on financial services except for non-discrimination. So that most favoured nation treatment that, is dictated by the WTO. So passporting rights are lost. This sector is obviously hoping that the EU will grant equivalent status in a number of areas, which would enable our financial services businesses to continue their current activities in many parts of the sector. But equivalence is not as good as passporting. Because it's normally granted for a limited duration and can be withdrawn at 30 days notice. So equivalence doesn't provide the same level of security for businesses. Obviously, as I said earlier, the TCA included declarations on both sides to try and reach this memorandum of understanding by end of March, that might mean that both sides agree on equivalence, so to recognise each other's rules. Whatever the outcome, if you consult with professionals or individuals within that sector, their general feel is that they're going to face segmentation and they're going to face complexity. So if a UK-based company wants to serve customers in an EU member state by setting up an office there, its market access and regulatory compliance requirements will now vary from one country to the other, whereas it was kind of uniform in the past. So experts are undoubtedly expecting the sector to be hit massively by the more restricted trading conditions, and actually advocates for Germany who promote Frankfurt as a financial sector are claiming that Frankfurt will benefit from a lot of relocation as a result of the EU and the UK not being able to negotiate better trading terms. So yeah, one of the sectors I think that will be hit quite badly, and it's painful because it's a sector that we have, like I said earlier on in the presentation, such strong brand awareness and recognition in the EU. Just want to touch on commercial agreements, because these should be looked at whether or not you are in the EU, in the trade of goods or trade of services. So, you know, we should be scrutinising our commercial agreement. Well, first of all, we should be having commercial agreements. We've traded in quite relaxed way with the EU in the past, but third country rules apply now, so having those contracts are really important. And I can't stress enough the importance of getting some expert advice on this to make sure that your contracts are sufficiently robust for the provision of services or goods to a third country. So, but if you have existing contracts, do they refer to the UK still being part of the EU? Do they refer to any kind of regulation that the UK is no longer party to? Do they, in terms of the trade of goods, do they expressly state what Incoterms you're using for the import or the export of those goods? Do they clearly define the territory that's covered, what the governing law is, what the dispute resolution is? Do they reference UK GDPR, which obviously, as I said, GDPR has now been incorporated into domestic law? And do they do they cover off all the vital components of a very robust contract? And I am by no means a legal professional, so I wouldn't even pretend to understand what all of those are. But do they also reference new burdens that are placed upon you as a business, and perhaps on your EU counterpart as well, as a result of the imposition of tariffs, the change of VAT rules, exchange rate fluctuations, and other costs that you might be incurring? So definitely seek advice in terms of commercial agreements. And then finally, just a quick checklist by means of things that you should be going away from today thinking about. So data transfers are hopefully resolved with the EU draft decision on adequacy. IP rights, just verify that any IP rights that you've registered with the EU Intellectual Property Office before the end of the transition period have been copied over or, you know, brought into UK rights by the UK IPO. That should have occurred automatically without the need for application, but just double check. Obviously with employees, if your company has an EU presence and you have employees currently working in the EU, check that they're already registered to work and live abroad with the relevant member state authorities. Any new employees now who are UK nationals travelling to Europe will now be considered third country nationals, so they'll need to get the right permits in order to enter, stay and work in that member state. Companies now have to make sure that staff travelling to work in an EU member state have the correct visas, so ensure that any that you know what those requirements are, and also ensure that any eligible EU employees living in the UK prior to the 31st of December have registered with the EU settlement scheme before the end of June. VAT, so as I said earlier, there's been no change to business supplies of VAT to EU companies. So the liability to account for the VAT is the EU company under the reverse charge rules. But just double check that, you know, the VAT systems that you've got in play within the company reflect all of that, and that you're invoicing correctly and so on. With regard to regulation insurance, you obviously now need to make sure that you're compliant with the national law in each jurisdiction. So do you have the appropriate levels of insurance? With regard to websites, if your company uses websites or technology services hosted in Europe, just contact them to inquire about the continuity of those services. Review the kind of terms and conditions of your contract with them. And as I mentioned earlier, if you have an EU web domain, seek to transfer it to prevent it being permanently suspended from the 1st of July. And then again, just another mention on visas. So understand the nature of the work that you're doing and what the applicable entry requirements are in that particular member state for the different categories of natural persons, so those short-term business visitors and so on. And that really is it for me. I have included, obviously services is massive, so there may be questions that you want to just pop me an email on, which is absolutely fine. My service levels aren't what they were before EU exit, but I will get round to you at some point. I was just going to ask if Richard has fixed his microphone yet. Are you there, Richard?
I'm not sure, Andrea. Can you hear me?
I can hear you.
Fantastic.
Well done.
I have a new camera, so I've switched cameras. No, I mean, thanks ever so much, Andrea. Thank you for a wonderful presentation. My name's Richard. I'm part of the EU Exit Advisory Team at Gloucestershire Growth Hub. Just to emphasise that today's webinar is one of a series of webinars and also part of a overall package of support that we offer to help local businesses tackle the challenges of the EU exit. So I'm sure this webinar today has answered lots of your questions, but if you do have any more questions, then please don't hesitate to get in touch with us, and we'll do everything we can to help you. And I will quickly drop my email details into the chat as well. But on that note, Andrea, back to you.
That's super. Thanks, Richard. I mean, I'm not pressed for time on this side. I don't have another call till 12. So if anybody does have any questions, I'm quite happy to take them if anybody wants to unmute themselves. This always worries me. It's either I've covered everything and you don't have any questions, or I've lost you all and you're having a mid-morning nap.
I mean,
sure.
Andrew, it's Richard again. I've had 2 or 3 questions come through.
Okay.
So, I mean, the first one is from a festivals and events business who's basically saying that they transport a lot of their equipment over to festivals and events in the European Union, and then obviously bring it back again. How do we avoid duties and tariffs? So I think you've already mentioned carnets, but did you just want to expand on that a little bit for them?
Yeah, so we're into the realms of temporary export really now. So that movement of equipment and so on would be subject to temporary export conditions, which means you can take the goods out of the UK for a certain period of time, and when they come back in, they're not subject to any duty or VAT. So an ATA carnet would do that. It isn't cheap, so it's typically around £300, and then you have to put down a security deposit as well, but it's usually valid for 1 year, and obviously globally recognised. There is where companies don't want to pay the fee for an ATA carnet. There is what's called a duplicate list, which is free, so it's something that you compile, but it's more complex. There can be more issues when you're bringing the goods back into the UK, and it's not always permitted in every country. So ATA carnets are costly, but again, they're valid for that 12 months and globally recognised and manage both the import and the export process.
Fantastic. Thanks, Andrea. I've just got a couple more, if that's okay.
Yeah, sure.
I've been contacted as well by a business who basically says that they've got workers that work across the UK, across Europe, multiple countries at the same time, and sometimes often at short notice, so they don't know exactly where the workers will be at any specific time. So I just wondered if you could expand on that. It sounds to me like quite a technical question that we may have to answer offline, but I just thought I'd ask it while
yeah, no, absolutely. I mean, it is probably something, if it is impacting them significantly, then it's something that we could take offline if they want to contact me, and I can give them a more full answer. But it is really looking at the individual entry requirements of each member state and allowing what is visa-free access, and that you can enter for a certain period of time without a work permit, and what's categorized as work that would require a work permit. And again, there's I can't even think, several pages dedicated to those different requirements by each EU member state in the trade and cooperation agreement. So there is a bit of a mapping exercise to happen, and to be honest, that kind of just-in-time provision of services just doesn't work anymore, because we do have that legwork to do before we can send people into the EU. So they perhaps can't be as responsive, as reactive as they could in the past, and they need to have those conversations with their customers that are expecting that next day provision, if you like.
Thank you, Andrea. And the last one that's come through to me is basically they're a Gloucestershire-based training company. So they offer training, both physical training, so people come to their premises to be trained, and they also offer online training. They sometimes get European people come over for their courses or join their courses online, and again, it's possibly quite a technical question, but they're saying their understanding is that they can carry on business as normal, and any onus of any new responsibilities is actually on the European people coming over. Would you agree with them, or would you? I know it's a difficult question.
No, it's not that the EU has definitely been more stringent in terms of entry requirements for UK nationals going into the EU, and the UK has been a lot more relaxed. So the government website sets out a number of different things, although if you look at it at the minute, a lot of it is around COVID measures, obviously, because there's an awful lot of travel happening at the moment, as you can imagine. But we are being somewhat relaxed, and it is absolutely down to the EU member state if they're sending employees into the UK to make sure that they've met the entry requirements that the UK government stipulated. So they're kind of right in a sense that it is down to their customers that are coming over, rather than for them to organise anything.
That's fantastic, Andrew. That's all the questions that have come through to me. So
okay,
again,
I do
thank you very much.
No, that's absolutely fine. I do have somebody who's asked if let me have a look. Is it possible to get a recording of the webinar? Absolutely. So we're recording, and the Growth Hub will send this out for you. Where can you find more details on digital trade and the use of VAT and tariffs? We provide online training. That's absolutely fine. I can give, if it's okay, Richard, I can give that information to the Growth Hub, and they can send it out with the recording and the slides, if that would be, that would be good. Absolutely, yeah. If you would, yeah, we can send that out. That'd be great. That's super. But I mean, thank you very much, everyone. That's an hour of your life that you'll never get back. So I'm sorry I stole it from you. But next week, I think it's next Wednesday, we're doing the border operating model. So we're talking more about goods than services next week. But I look forward to you all joining me then. Thanks very much, everyone. Take care. Bye-bye. Bye.